Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us for our Tuesday night live program. Every Tuesday nights, a little about 6 p.m. We do Scott's time, which is about 6:05-ish when it comes to doing this on Tuesday night. Thanks for joining us. Like I said, we appreciate everyone being here. We know that you have other things that you could be doing, and we appreciate you taking the time to be here. What a day. What a day. I'll talk about that in a minute, but I want to let you know what we're going to talk about. First thing I want to talk about is a little bit about the Alec Murdaugh hearing that took place where he was denied his right to denied his request. He doesn't have a right to a new trial, but he denied his request for a new trial there in South Carolina for the death of his wife, Maggie, and son, Paul. But I want to talk about a little bit of the nuances of that particular hearing as it relates to what the judge said about the clerk, Miss Hill. Okay. People kind of glossed over it, but I think it is of some significance and worth noting. And obviously, Richard Allen, things are going to get nasty in the Delphi murder case. The judge doesn't like the defense attorneys, which, game on, bring it on. And the prosecutors don't like the defense attorneys. In fact, they filed a motion for contempt today of the new old attorneys that were put on the case. So I think that's going to be talking about. And then, of course, the Crumbley matter. Okay. The Crumbley matter obviously is a situation of, it's a horrific case, right? It always is. Anytime you have one of these cases, it involves some kid going in, doing terrible things at a school where other kids die. That is obviously terrible. But then you have the trial of Jennifer Crumbley, who is charged with she is charged with contributing by not knowing enough of the warning signs of what was taking place. And I'll kind of maybe bring that into, if I can, it's an ongoing case, but let's just say we had a good day in court today. And that was one of the reasons why I didn't get to put up a video today, but fortunately it was our Tuesday night show, so we can do the live. And then, of course, obviously we have our dumb criminal of the day, as well as your questions and comments. All right. So we will do that. And so let me just, good day in court. Okay. So it's not uncommon. Let me just give you an overview. We'll leave out the names to protect the innocent. All right. But it's not uncommon when somebody gets arrested for a particular case. If there is a victim, oftentimes the victims are advised to go get a protection order. Okay, fine. So a protection order hearing is as close as you get to the wild, wild west. All right. This is the way attorneys used to do it back in the day before, big fancy, here's discovery and here's your disclosures. You literally, let's go. You get handed the exhibits from the petitioner. If you got any, you give them back and forth. That day, it's wild, wild west. And so we go to hearing, and I'm, Mr. Reasonable. I'm trying to say, hey, we can resolve this. Let's just put something in place. Couple of months, no problems, goes away. Let's just be done with it. The attorney's like, no, we're not doing that. Oh, okay. All right. Well, I was just trying to be reasonable because that's my middle name is Reasonable. So we go to hearing and, we just get the exhibits. And I'm like, okay. I mean, I get the exhibits and I'm like, okay, I'll try to keep these out, but I got some good questions if this comes in. And, the allegation was not anything particularly complicated, but, unwanted repeated calls, that kind of deal. And so the petitioner's attorney gets admitted the phone records of the complaining witness in the case. And, she traumatized, uncomfortable, horrible, worst day of her life. Goes through all these incidents. Tells the police terrible stuff. It was terrible. The whole day. Terrible, terrible. Oh, so traumatized. And we told the police officers you didn't have any communication with that. You turned your phone off. Did you? Yep. About midnight, right? And you woke up and there were 27 text messages. It was terrible. Oh my God, terrible. Worst day of your life, right? Yep. Well, let's just take a look at this page here. This says the police testified this under oath. Oh, well, why did you have that, 54-minute telephone conversation at 3 a.m.? Oh, look, and there's another one like at 4:08. Huh? Can you explain? Well, blah, blah, blah. Let's just say cross-examination, okay? The greatest truth-seeking tool ever created. If we had cross-examination, not only, courts, obviously, but, people actually, let's just say when we got done, the judge didn't grant their request for the protection order, okay? Didn't grant that. And then on top of that said, the fact that you cherry-picked these incidents and you were not truthful with the police on direct examination, it wasn't until cross-examination by yours truly that all this information came out. The judge found her not credible. Not credible. Okay. I used a little harsher word. Starts with an L, starts with an L, ends with an R. And let me just say the other attorney wasn't. But here's the beautiful thing. Here's the beautiful thing, ladies and gentlemen. I thought things were going my way. But you always want to look out for the best interests of your client, which is, certainty. Certainty in the law is always better than uncertainty. And so we take our break and, I said, hey, man, I think things went pretty well. Well, you intimidated my client, blah, blah, blah. I didn't intimidate anybody. Just brought out the truth. That's all. I understand if you're not a worthy opponent and we're unable to bring out the truth and deal with it. Fortunately, I was here, so I understand that. But I said, here's the deal. We'll let you do the 90 days. Still offers on the table. Certainty. I said, because you could lose. And I could win. I just got a feeling. I think things went pretty well. And, of course, the attorney comes back to the huddle. It's terrible. Oh, terrible. You were mean. You were mean. So I came back, and they told me, no, we're not doing it. And then the judge denied their request for the order. Okay. And this is, protection orders, a lot of people do them on their own. Usually they're kind of a rubber stamp. So to go in and win one was good. And when the judge says the witness is not credible, just like the Miss Hill in the Alec Murdaugh case, they're using nice words. When they say, oh, you're not credible, you have some credibility issues. What she's saying is you're a liar. Okay. And that's what the judge said in the Murdaugh case that we can talk about in a second. But that was my day. Okay. And it was good. And what I loved about it, it was at the old courthouse. It was at the old courthouse here in Denver. They have this new glass monstrosity. It's a piece of garbage. The security guards, everybody sucks. Everything about the building sucks. And you got to go in the old courthouse, the old kind with the big round rotunda, almost looks like a state capitol, but it's the city and county of Denver building. And they had all of these courts in this building for years. I think it was built like 1908. And now we go to these. And the reason why they had to have a new courtroom was because there was a holding facility on the 4th floor for all of the in custodies. And so they would walk the in custodies down the hallway in shackles and whatever. And if you had a case, the news media would be there filming the guy walking down the hallway. And they said it was a security risk. We need a new jail. So, of course, they get this ugly new jail, which doesn't run as efficiently as ever, as the old courthouse ever did. And it was just nice. It was like taking a stroll down memory lane. So when I was getting the request form to get the transcript of the hearing so that I can present that in the criminal case to the prosecutors, think the judge already did your job here. Let's take a look at this, won't you think? And so anyway, that was a fun day, because it's like the old Wild West. You just show up and let the best lawyer win. I'm telling you, it was amazing. I love it. Cross-examination. It's literally, I mean, being a lawyer some days is exhausting, but when you win and the judge basically says the complaining witness was a liar and said the fact that you cherry-picked this and this young man got arrested, she said that's very disappointing. Very disappointing. I would say it's very disappointing. I would almost say, I don't know, maybe some charges, perhaps. Maybe some charges against that young lady. But, probably not, because that's not the way they do it. We're not going to re-traumatize anybody. No, let's not get the truth. Let's not do that. So anyway, let's talk about some stuff. We got a lot to talk about. Here we go. So the judge in the Alec Murdaugh case. Now, we brought you the entire hearing in the Alec Murdaugh saga that continues yesterday. We did our show, and then later in the afternoon, I had to go to court, but I was watching as I was driving to my court appearance, and watching the judge. She didn't rule. I think I was actually driving back, because I don't think she actually delivered her opinion until after 5 p.m. on Eastern time. So I was driving, it was like 3 something here, I think. And I'm driving back, and she's like, hey, I've looked at this, and let's face it, Miss Hill, she had credibility issues, and she lied, okay? You can say what you want. Lapse of memory. You could say she forgot, she didn't recall. She lied. Let's call it for what it is. She lied, okay? And the judge all but said she lied. Remember, Miss Hill is the clerk, right? People said she said these things. The question was that in and of itself enough to get a new trial? I told you on our show yesterday. Didn't think it was going to be. Why? Because the juror who testified that said that she was so influenced made her decision. And then when the judge polled the jury and said, is this your decision? She said yes. Okay? And this is why it's so important, ladies and gentlemen, in any trial. I don't care if it's a civil case. I don't care if it is a criminal case. If you are not 100 absolutely percent convinced that whoever's moving forward in the civil case, the plaintiff has to prove their case by preponderance of evidence. In a criminal case, the prosecution has to prove it beyond a reasonable doubt. If you think there is some doubt, it is your solemn oath and obligation to say not guilty. And if they prove their case, it's your solemn oath and obligation to say guilty. But to then have buyer's remorse, that's what I'm saying. There is no buyer's remorse. Oh, well, I thought about it, and, there really was doubt, but the other jurors just convinced me. Well, guess what? Your vote is just the same as everyone in that deliberation room. It doesn't matter if the other person has a PhD in criminology or they're a doctor and you're just the old ditch digger, an honorable profession, I might add. And if that person says, nope, didn't prove the case, don't change your mind. If you are absolutely convinced they didn't do it. Now, don't do it just to be difficult. Don't do it just because you got a grudge with somebody else. You have to follow the law. But if you don't believe that the party hasn't proven their case beyond a reasonable doubt, don't say guilty. For goodness sakes, don't say guilty. And it's the other way. If you're 11-1 in the jury room and one way or another, everybody's saying guilty and you're saying, no, I think they prove it, don't give in just to go home early on a Friday afternoon. It's been a long 6 weeks. We've been here about 3 hours. I think we pretty much can wrap this one up, right? So I didn't think that they were probably going to make enough of a showing to get a new trial. But what I think the defense did do, and the judge agreed, was that Ms. Hill, as the judge said, Miss Hill was attracted by the siren call of celebrity because she wanted to write a book about the trial. And we've talked about this before. Why is the clerk, who's still working as the clerk, got a side hustle of writing a book? No. You're a public employee. Yes, you're elected. All the more reason why you should be focusing on the people's work. Maybe if you've been focusing, Miss Hill, on the people's work, you wouldn't have time to make these comments that the court made a finding that they were said. But it wasn't enough to change the verdict. So Miss Hill made these statements. The judge basically believes she made these statements. And but she wasn't going to grant a new trial. And the judge said, hey, I reviewed the transcript. I understand how the jury could come to this conclusion because basically there was overwhelming evidence in this particular case as well. I was just looking here something real quick. I got distracted. Okay. Uncivil law. Pro se is planning to go pro se again for round 2, though, because he has a death wish despite having resources to hire top lawyers. It's amazing. Not sure what they're talking about there. Anyway, got distracted. Sorry. Anyway, so it was interesting. Murdaugh's attorneys basically said, and this is the part that I get, all right? Griffin said that they had indications from lawyers representing jurors that they needed to talk to Hill. And she told us things that were jaw-dropping. And then Griffin continued, we were denigrated, made fun of in our filings for pointing out that she had a profit motive for this, and the judge agreed with us. And this is the part that's probably one of the toughest things about being a criminal defense attorney. You go there and say, we have a true injustice that's taking place. We think there's a problem with your lab. We think you didn't pick up the big rock that the guys were coming at before they were attacking my client. And they look at you like you have a third eye on your forehead. They look at you like you're an idiot. And they denigrate you. Oh, why are you wasting the time with these frivolous motions? God, we know your guy's guilty. God, why can't we just get over this? Why don't you just let this go? Well, can you explain? Because I have a good faith basis for it. And this is what people don't get. Lawyers don't just file motions to file motions. You must have a good faith basis to file these motions. Otherwise, it's deemed frivolous and sanctions could be imposed. Clearly, Murdaugh's attorneys had a good faith basis to file this. They had a juror who said she was swayed by it. Had the alternate that didn't deliberate that said she made all these comments. People said she did it. She, released all this information to the news media and said it was all mistakes. So, Becky Hill, basically what and it's up for appellate review. But as you may recall, obviously Murdaugh was convicted last year, 22 actually now. He's up on appeal. They get this information about this juror and they say, hey, judge, we've got an issue. So they asked the appellate courts in South Carolina to remand the case back to the trial level. Judge Newman was out. He retired. But once again, why is he making comments about these cases? Don't get it. Don't get it. Don't get it. But he did. The judge says we're going to have a hearing because the Supreme Court, or not Supreme Court, but the appellate court say we're going to have a hearing. The Supreme Court appoints this Judge Toll, who is a former trial court judge and state Supreme Court Chief Justice there in South Carolina. No nonsense woman, for sure. She ran a tight ship, but she also, I loved when there were statements where Miss Hill got up and they wanted to call witnesses to impeach Miss Hill, to call her a liar. I know lawyers aren't supposed to call people liars in court anymore, right? Oh, they speak with forked tongue. Your Honor, they're not being completely truthful, right? Here in Colorado, you can't tell a jury that the witness is a liar. You have to come up with every other kind of descriptive word to say they're a liar without saying a liar. Okay. And those are the rules you got to play by. But at the end of the day, liar. Ms. Hill, judge said liar. And so they remanded the case back. They're going to have this hearing so they can develop the record. Now, in theory, is this done? Probably so, right? The Court of Appeals, they're smart people there in South Carolina, the Supreme Court. They're like, man, we got this judge. Can't have Judge Newman do it. He's retired, and he's probably a witness as well. He was, but they weren't going to call him because of his status as a judge. And so they had the judge question the jurors that, if you saw the standard questions, did you hear any statements by Ms. Hill? Would it influence your decision in any way? No. Just the one juror. And so there you go. They've developed the record. The judge has made her findings of fact and conclusions of law, where she applied the facts. The facts are, we interviewed all these jurors. One juror said she was influenced. Another one said she didn't. Ms. Hill got up and testified. Basically, she said she's not credible. Okay, if a judge says you're not credible, the judge is politely saying, you're a liar. That's just the way it is. You're a liar. And that's why I found Ms. Hill. Ms. Hill, I don't know if she's resigned, but I would. I mean, you're the clerk of the court that's been found to be not credible, have credibility issues. Your integrity is a question by a Supreme Court judge. And why she would not resign now? Well, probably because she needs the money, because she's got those other little investigations going on, one involving her son, who just happened to be wiretapping calls, as it related to this investigation. She panicked. All right. I get it, Ms. Hill. You're the clerk of the court. This is the biggest thing to ever come to Colleton County in your day. You're the elected clerk. You're thinking, hey, this is an opportunity. I can make a few extra bucks. Hey, I get it. But quit your job, because, it's the old thing. You can't serve, two people, two masters, I think is what the phrase is. Your job is to be the clerk, but at the same time, are you taking copious notes and trying to sway the jury? The judge asked her questions about her book. And she's like, well, that was a little poetic license is what she referred to it as. And the judge is like, well, that's not poetic license. That's you saying various things that you tried to do to influence a jury. So I hate to say it, but Murdaugh was right. Ms. Hill, and I would have given him a new trial. Him a new trial, but I understand how the court came to this particular issue. Okay. The fact that the clerk was trying to influence this jury, however subtly, in the position that she was in. Okay. Remember, if you haven't been to jury duty, right, you get selected. Your interaction as a juror is with usually it's the courtroom clerk. Here it's the big case. So they brought in the deputy, the clerk of the court. It's not like, you go back in, the jury room and the judge comes in and chats with you. You don't. They all huddle together. But the one person they know, they learn, and they trust is the judicial clerk that is there, bringing them in and out, asking their questions. Hey, the parking meter didn't work today. I got a sick kid. Can I leave home? Right? They learn to get them, trust them. And if you're doing something inappropriate like that, that's wrong. As a defense attorney, I get it. I would have granted a new trial. But when you look at the record that was made, I understand how the judge came to her decision. And we've talked about this before. This is the SOB rule. Okay. And if you're new to the program, what is the SOB rule? Okay. The SOB rule is the defendant is right. Here we know the court found statements were made. We have a juror said it influenced them, but not going to reverse. What did she really say? She described the SOB rule. The SOB rule is The client is an SOB, okay? And clearly legal errors were made. And if this was a close case, we would give him a new trial. But what did the judge note? Well, I've reviewed the record, and I can tell you there's overwhelming evidence here. Overwhelming evidence. And it wouldn't have made any difference had Ms. Hill influenced all of these jurors. They made the decision on their own, per their statement today, right? I mean, some jurors aren't going to say, oh, you know, I told the police that it didn't influence, and maybe it did, but if I change my mind, then I'm going to get in trouble for not being truthful to SLED, South Carolina Law Enforcement Division. And so they're stuck with their statement. And I'm not saying they lied. I'm not putting that out there in any way whatsoever. But they're into that statement. And what the judge should have done early on was say, let's get everybody in here before anybody else investigates, and I'm going to ask these jurors what was done. But, you know, all these jurors getting lawyers that just happen to be being represented by the attorneys that were suing the Murdaugh people. I mean, it's just a little weird. So the Judge Toll, the retired Supreme Court justice who was appointed to hear about this case, conduct the hearing, which I thought she did a good hearing on. And I think the truth came out on cross-examination. I'm telling you, that is an example. All right. The confrontation clause, ladies and gentlemen, the confrontation clause, the greatest truth-seeking tool ever created anywhere in the world, right? Could you imagine if you actually had a confrontation clause, like of those people on TV, and they just say something and they act like, that's it? Not subject to cross-examination, where they actually have to answer, not just, conflate, when they actually be told to no, answer the question under oath with the pains and penalty of perjury. Like I said, and when you're the clerk of the court and the judge says not credible, ooh, ouch, ooh, ouch. Ms. Hill, I'd be looking for a new job. And I like the way the defense was like, hey, man, everyone thought we were crazy. We were ridiculed. We were this and that. And don't get me wrong, Murdaugh was guilty. But even the prosecutors, I can't even believe. Why do we have to even do this hearing? Right? And did you see the prosecutor when Ms. Hill testified and the defense was like, Judge, got this affidavit, and I'd like to call a witness to completely contradict Ms. Hill's testimony. And the district attorney general, oh my gosh, Judge, the proper rules for impeachment were not put into place, and please don't do this because she's a clerk, and I'm an attorney general, and we stick together. And if you start saying that somebody in the government did something wrong, it makes us all look bad, like we could all do things wrong, and we can't have that. Oh no, we can't have that. And the judge allowed it. Like, no, I think he meant. In fact, I went through the affidavit, and Mr. Harpatulian was like, no, Judge, I was doing this, right? And it's impeachment, okay? Impeachment is, attorneys have to set it up properly, okay, to bring in somebody to do that. Like, isn't it true? They asked the witness, isn't it true that you spoke to juror A and said this? No, I deny that. I never spoke to juror A. Your Honor, we call juror A to do it. You got to lay the foundation, okay? Oh, you're saying you did not talk to juror A, let's be specific, on this date, in this location, and you didn't say this to the juror. Is that correct? Yes, it is. Okay, let's call in juror A. Juror A, what were you doing on this particular date? Where were you? What were you doing, and who were you speaking with? And what did that person tell you? That's the way you appropriately do that. I thought Harpatulian was close enough. The judge says, hey, it's a motion hearing. The rules of evidence are a little more relaxed here because we're seeking the truth. But don't you just love it when the prosecutors get well, Judge, we can't do that. This is beyond the scope of the hearing. And judge is like, she's a retired Supreme Court justice that knows the rules of evidence. She's like, well, under 613, 614, 6 away, I'm going to allow it. And they're just flailing. And I bet at that point, the attorney general there, and I can never remember his name. I apologize. God, why can't I remember his name? But doesn't it start with a W or something? God, it just drives me bonkers when I forget names. Anyway, he was like, oh, no, we can't do this, judge, exceeding this. Because you're making your key witness look bad. And the one that SLED, remember, it was SLED, South Carolina Law Enforcement Division. I'm sure they're lovely people. Don't know them. Hope to never get to know them. But remember, SLED conducted their investigation, and they found absolutely no misconduct on the part of Ms. Hill. No inappropriate statements. Well, that's funny because we had a hearing, and the judge said Ms. Hill was not candid or credible with the court. I think... I deal with this stuff on a daily basis. But why are people not a little more outraged? Maybe they're saying, well, it's just the government. They do it. But, you see how it is. I agree with, don't get me wrong. Murdaugh, I think he's guilty. All right? I've said it before. He's been convicted. He's guilty. All right? That voice message on the TikTok that has him down there at the exact time of the murders, done. Put a fork in him. He was done at that particular moment. Okay. But guess what? I get it. His attorneys are like, hey, our client's an SOB, horrible human being. But guess what? On my watch, that's my horrible SOB, and I'm going to do everything I can to protect his rights. So I completely respect what Murdaugh's defense attorneys have done. That was good lawyering. All right. And then they get ridiculed. Why are you doing this? The prosecutor, this is ridiculous. I have personally, conducted an investigation with SLED, and this is just a waste of time. I'm not sure why we're doing this. And then the clerk of the court who wrote a book about a case, well, she's supposed to be working, is found to be not credible because she lied, ladies and gentlemen. She got caught in lies. And what she should have done was simply, taken the fifth, maybe even a don't recall. But she lied. And the defense attorney set her up so beautifully. Set her up. The defense attorney was asking those questions because he knew the answer to it. And the fact that she lied, my gosh, it's just... Anyway, I don't know. Let's see here. Cheslamez. I think the alternate juror is the one suffering from sudden star status. I don't believe her. And besides, Rhonda, the substitute clerk, saw and heard nothing, never said anything to the judge. I get it. But a retired Supreme Court justice sitting at appointment of the South Carolina Supreme Court that conducted the hearing said she lied. You can't dice it any other way. Okay. Frankly, Miss Hill, she's probably resigned. Should have taken the fifth. Should have said, oh, I don't recall that. Oh, my memory's fuzzy. All this, so fuzzy. But she's like, oh, no, I never said that. Okay. Call the next witness. Okay. And I get it. The alternate juror, maybe she brought it out. Maybe she has a beef. Small community. I don't know. But the point was they had a good faith basis for it. And like I said, so we have a clerk attempting to influence a jury. It makes you kind of wonder, well, did she just do this for the big case? Or did she do it for all cases where she thinks somebody's guilty? Right? That's the problem. What do they say? Nobody gets pregnant the first time, so to speak. Nobody gets caught their first time. She thought she could do it. She knew the world was watching. And yet, she's still trying to get away with it, trying to influence. So anyway, I don't know. It's interesting to me. It goes back to the point we made all along. I don't think anybody in public office should be able to do a side hustle, do any other kind of job. That's just the way it was, the way it used to be. If you work for the government, you don't get permission to go do a second side hustle while you're supposedly doing your job, let alone writing books about the job that you're supposed to be doing. Maybe if you're the clerk master, you write a book for all the clerks in South Carolina, you could probably do that in your spare time, but you certainly shouldn't be allowed to profit from it. The book that all the clerks buy or something along those lines. It just creates situations like this, right? The general rule was, I'm speaking for attorneys, right? The general rule was, if you were an attorney, you go make your bones working for the government, you get the experience, you go off to private practice. It was never a lifelong career for, professionals to go work for the government, right? Usually it was because, well, you didn't make a whole lot of money because you didn't have a whole lot of experience. Once you got that experience, you moved along. And now everybody thinks they can do these side hustles. I see these senators, I can't make it. I just can't make it on my salary in Washington, D.C. And I need to have my podcast. I need to do this or that. Write a book. Oh, okay. Why are you writing a book? Because you want to go make private money? I guess go be a lobbyist, which I don't think they should be allowed to do that either. It would be a lot cleaner if public servants were not allowed to do that. But, all right. I think we've talked about that enough. Judge Toll did a good job. Alec Murdaugh not getting a new trial. But guess what? Now they have another issue on appeal. But I don't think it's going to be a strong one because the judge had the hearing, made her findings of facts, conclusions of law, and threw in that little knife and twisted it in the back of Alec Murdaugh saying, you're an SOB. And although there was error, we find it harmless in light of the overwhelming evidence. That was the appellate court judge talking at the district court level. Although there was error, it was anyway, there we go. All right, let's move on. Another good one, Richard Allen. Okay, we'll talk about this and we'll talk about Crumbley. Richard Allen, right? Delphi murder guy. Cops couldn't get their act together as it relates to finding the alleged murderer for like 7 years. Why? Because a hired clerk for the FBI forgot to index the report where Mr. Allen talked to a police friend and said, hey, I was in the area that day. Do you think I should go talk to somebody? Yeah, you should. Hey, I just want to let everybody know I was down in that area about that time and didn't kill anybody, but just want to let you know I was there. And then for 7 years, they can't find anything. They got all this pressure. Why can't you do anything? Why can't you do anything? Somebody goes back through and they're like, why did we not have this in the file? Oh, really? Somebody didn't scan it correctly? Yeah, we should probably go talk to this Richard Allen guy. We should probably go get a search warrant for his house. Yeah, that's what we should do. Yeah, let's go arrest somebody. All right. So Richard Allen gets arrested. He gets charged. He gets a couple of attorneys, Andrew Baldwin and Bradley Rozzi, and they hit the prosecution hard. Okay. They go after them hard. And they're supposed to have this motions hearing. But the judge gets wind that, hey, there's been a breach of the protective order. That is the most heinous breach they've ever seen. And the prosecutor will have spent 7 days, 24/7, working on this breach of the discovery order, the protective order, and the protective order regarding the discovery in the case. And by God, hell will be paid by the people that violated this protection order. Well, what's the violation of protection order, Scott? It seems pretty dramatic, isn't it? Yeah. So I can't remember which one, Andrew Baldwin or Bradley Rozzi, had a former office manager / paralegal who still did work for them occasionally, came by the office and he's like, wow, is that the Delphi war room? Yeah, it is, man. Check. Oh, look at this. It's huge. Look at all these boxes. Look at the paperwork. Bazillions of pages. terabytes you wouldn't believe, hard drives. Yeah, it's crazy. Oh, yeah, what are you working on? Man, we're probably working on this motion. There's no way this guy could have done it himself. We've got the motion of all motions. It's 132 pages. We are going to kick the prosecutor in their teeth. They have no idea that we're coming because, they're probably Odinites that have their head in the sand. If you talked the story before, you know that's the Odinites are the one that did it. It's all part of the greater conspiracy to frame Richard Allen. And it's like, okay. And one of the attorneys is like, just hold on. I got to talk to you about a minute about something else, but I got to go take this call or something. And I'm taking in the words of Miss Hill, a little poetic license. I'm just trying to set the stage. But you have a former employee, you trusted them, you're your office manager. So unbeknownst to the attorney, the former office manager starts looking around. What's that? Let me look in there. Oh, those are the photos of the kids. Ooh. And so the former office manager starts taking pictures. Oh, look at that. Oh, look at that. The office manager then sends him to somebody else, I think in Texas. Maybe he sends him to somewhere else. So anyway, former office manager is charged with a misdemeanor, but the DA worked 7 days, night and day to figure out, terrible. Where does it stop? It's a travesty of a mockery of a sham. First, we let out crime scene photos. The next thing you know, they'll be learning the truth about the case and how we screwed it up from the beginning. Right? And I think one of the persons that the items were sent to and the police knocked on his door talks to the cop. Oh, I don't know about nothing. And then I think he takes his own life. Sad story. And that was it, right? That was me knocking on the door, Frank. Anyway, so the judge has this hearing back in October-ish and basically calls Baldwin and Rozzi a bunch of incompetent boobs. How could this ever happen? And then she basically says, I'm going to go out there and embarrass you to the nth degree unless you resign because you are incompetent and I want Mr. Allen to have effective assistance of counsel. Bradley and Rozzi or Baldwin and Rozzi are like, I had no idea what the heck is going on here. Like, Judge, I mean, we've cooperated in every way. I mean, things happen. No malintent on my side. I mean, we didn't tell them to take these photographs. We had no knowledge of it until this broke and we've cooperated. I mean, and we've read the transcript. And the judge basically says, resign now or I'm going to embarrass you. And they're like, okay, well, I guess I resign, I guess. And so the judge basically fires him. I've never seen it. In 29 years of practicing criminal defense, never seen an attorney fired by a judge because the judge says you're incompetent. Never seen it. So, of course, everything blows up. Defense attorneys are, like, what's going on? They finally regroup. They have a couple of days to think about it. Like, hey, she can't do that. She can't just fire us. We have an attorney-client relationship. She can't interfere in that. And so the court then appoints two new attorneys. So now we have like the old attorneys, the new attorneys, and now we have the new old attorneys that are back. All right. And so the old attorneys, Bradley and Rozzi, file extraordinary writ to the Indiana Supreme Court. The Indiana Supreme Court agrees to take it. A couple of things. They say, hey, first of all, judge can't fire us. Two, the judge should be off the case based upon her conduct at this point. And three, you're violating Mr. Allen's right to a speedy trial, and we want to trial in 70 days. And she purposely did this because the prosecution wasn't ready. Okay, I threw that one in, but that was the gist of it. Prosecution, so not ready. So not ready, okay? They're never ready in big cases like this in small towns. They never are. Write that down. Scott Reich said, prosecutor, small town, big cases, never ready when they say they will be, okay? Learn it, know it, live it. It's the truth. Indiana Supreme Court hears it. They issue a ruling that same day and said, you know what, you're right. This is an extraordinary thing, but we agree the judge shouldn't have fired you. But all your other stuff, you should have gone through, getting rid of the judge. There's a process for that, and you didn't do that. So new, old attorneys immediately file a motion to recuse. We talked about this, I think it was Monday. Boom, boom, throwing punches at the judge. Hey, judge, you screwed up. You're not good. The appearance of impropriety, of unfairness that is oozing off the bench when you're there and we're there and Mr. Allen is there, you should just recuse yourself now. And oh, by the way, those mother of all motions, a Moam, remember that mother of all bombs, the Moab? Well, we have the mother of all motions, and you didn't even read them. They were 132 pages long, and you gave like a 4-page order saying, denied, didn't bother having a hearing whatsoever. Clearly, you're biased. You're an idiot. Judge, you should get off the bench. At least Mr. Allen's case. We know you just got promoted to your new judge as like chief judge of the district you're in. So basically, that's a fancy word for you're now head administrator. You're head of HR. You're head of everything. Chief judge just means you don't sit in the courtroom every day. It means you take care of all the administrative matters of the courthouse, the personnel, the hiring, the firing, pay increases, disputes between employees. That's what chief judges do. Okay. And so now the prosecutors in the final blow are saying that the attorneys should be held in contempt for violation of the protective order. There you go. Can't make this stuff up. So instead, where the people that are allegedly violated the protection order said, I didn't knowingly violate it. Okay, you can make all the arguments you want. You're right. I shouldn't have trusted that former employee. I should have guarded him at every moment, even though he's a trusted friend. Use common sense, ladies and gentlemen. You have a good friend, someone you trust. You'd never think in a million years that they're going to get you in trouble, and then they do something like that, right? Prosecutors want contempt. No, they're not working on their case to make sure they convict the guy that they think killed 2 young girls. Let's waste our time trying to hold the defense attorneys in contempt. Hey, and if you want to do that, hell, if you want to grieve them, go do that. But do it after the case is over. It's just ridiculous. Go try your case. You know what? Why don't you agree if you're so ready to go, Mr. Prosecutor? Say, I'll do this trial in 70 days. You tell me where, you tell me when. We'll show up with our witnesses, our experts, and we will be ready to go. Why is the prosecutor never saying that? Never says that. No. We want to issue contempt proceedings against the 2 attorneys. This is going to be a contentious case. And if I believe correctly, the case that was supposed to start, I think, on January 24th, so last week, was this case, obviously didn't go. It was supposed to be televised, which it should be. It absolutely should be. But it's going to be a knockdown, drag out street fight here. That is what it is. That is what it is. It is a street fight. You got a judge, doesn't like the defense attorneys. You know that's always going to be good because the defense attorneys are going to be like, Judge, you tried to get me to me once. Oh, and the Supreme Court slapped you down. Boom, boom, boom. So why don't you treat us with a little bit of respect, all right? And do your job and call some freaking balls and strikes and take the time and maybe have a hearing on a Frank's issue. Listen, you want to talk about appellate issues, right? A prosecutor, not only is their job to do justice, but to win cases ethically, right? And to do justice is not about winning. That's the prosecutor's ethical rules. Their job is also to protect the record, okay? When somebody presents a 132-page motion saying that there were some discrepancies in the affidavit for the arrest warrant, search warrants, all that good stuff. That's kind of error on the part of the judge. That's how cases come back. Just like in the Murdaugh case, right? Had they filed their motion, here's our affidavit, juror says she was influenced. Court of Appeal reads that cold record and says, wow, should have had a hearing on this, or we're just going to grant a new trial. Let's just go for it. It's the same thing. We don't grant a hearing on something like that. Appellate courts will say, yeah, you should have had a hearing on that. Yeah, judge, you erred. Should have been an issue, but it should have been allowed to be explored a little bit. So, yes, I don't know. Judge Fran C. Gull at all. She apparently is a very good judge. I'm assuming she is. But let's face it, ladies and gentlemen, she got embarrassed. Kind of like Judge or courtroom clerk Deputy Hill, clerk of the court Hill in Colleton County, got embarrassed. Judge Frances C. Gull got embarrassed by her bosses at the Supreme Court and said, you screwed up. Go back. Okay. I get it. You think, oh, they're judges. They got tough skin. Listen, they're like anybody. They don't like to be wrong. They don't like to be told that they're wrong. And judges, I'm just telling you, just a little practice pointer here. Judges don't like to be told that they're wrong or that they made a mistake. They just don't like it because, my God, they're judges. If you haven't noticed, they're wearing a black robe. They were appointed by the governor, for goodness sakes, in some states. How dare you question my authority? I am a judge. Okay, judge, cases get reversed all the time because you're wrong. Oh, and little old me, little old street lawyer Scott Royce was correct. And you looked at me like I was an idiot. You even made, comments on the bench. Why are you objecting so much? Because it's my ethical obligation to do so, Your Honor. Well, I'll give you standing objection. Well, Judge, some courts find the standing objections aren't sufficient enough, so I will make my contemporaneous, timely objection on each question that I believe is objectionable. Well, that turns out to be every question. Yes, it does. Sorry about that. Just protecting my client. And then guess what? The case comes back because I objected. I objected to the thing that the prosecution, who thought he was right, and the defense and the judge who thought he was right. And little old me was ridiculed, mocked, pressured to not do my job, and then it comes back on appeal. So it's just the way it is, ladies and gentlemen. I mean, so Richard Allen, the judge, maybe she just needs to go away, just out of the appearance of impropriety, not being fair. Okay, and don't get me wrong. If you're going to recuse a judge, it's a silver bullet, right? You better strike, with that one if you're going to, do it, because they will remember. I assure you. Okay. And as I found out recently, I had a judge that I was talking to and known forever before they were a judge, and did a trial, and it was a very contentious trial. I had a client that we referred to as he was like Murdaugh, the SOB. Nobody liked him. Tough client. Tough client. Anyway, I get up at sentencing because, the prosecution was supposed to do something pre-trial. They didn't. And the judge's like, well, it's the SOB rule. We really got to convict your guy because, he's a bad dude. We're going to let the prosecutor do what they want. And I got up at sentencing and said, normally, Judge, I can say that, we respect the results of the jury because it was we received a fair trial. But I can't say that in this case, Judge. I think the court made some rulings that were unfair, and it resulted in an unfair trial. Judge reminded me of that. This is like 7 years ago. So they remembered those things. Okay. When you were accused, you go after them, they remember them. Now, I'm sure the judge will be pleasant. I have no animosity toward the judge. I was just doing my job, and she was just doing hers. And, there you go. But hey, it's just the way it is. And so the Richard Allen case is going to be a knockdown, drag out fight. And I can't wait. And I hope that he gets that trial within 70 days, even though the previous court had set it out into October. I really do hope that they say, let's go do this thing, right? Where's the prosecutor? Prosecutor like, we've had 7 years for this case. Let's go do it. The defense is ready and the prosecution, well, judge, we can't do that. October is, oh my goodness, right? Kind of like the Kohberger thing. I don't want to get too excited on Kohberger, but we could talk about Kohberger for a while. Let's talk about Kohberger for just a second, and then we'll talk about the Crumbleys, all right? Kohberger, the judge, yes, he waived speedy trial, and under that provision in Idaho, as I've learned to understand out there, is that, you waive speedy trial, there's no real big rush to get him anywhere. The defense doesn't want to start the Kohberger trial until next summer. I get it's a death penalty case, and she says, oh my God, there's so much discovery. There's so much discovery, okay? And this is what I think has changed in the practice of law, ladies and gentlemen. And you can quote me on this too. A lot of people will disagree, but they're always looking for a document. They're always looking for the smoking gun to go help their client or something along those lines. It's not there, okay? Brian Kohberger's defense, as we know it, is that he was not there, and that is it, okay? The defense has the best shot of winning by saying, we are ready to go. Let's go do this thing. Prosecution's got to be the one to prove their case beyond a reasonable doubt to each and every element of the offenses charged, right? That's their obligation under the United States Constitution, and one that every prosecutor should readily accept and say, we're ready to go do our job. But what do they always do? Well, there's, judge, I'm telling you, there's a lot of discovery out there. That's what the prosecutors say. Well, can't necessarily disagree, judge. There's a lot of discovery. And we're just getting it ourselves because did we mention there's a lot of discovery? And so they go on. And the judge is looking perplexed, like, 2025? And like, well, judge, we don't want to disrupt anybody. We're going to probably keep it here. We don't want to change a venue. Let's keep it here. I think it's crazy. It's not a big city. We saw in the Lori Vallow trial, even there in Boise, they found people that knew about the case. And yes, the standard is not that you know about the case, but whether you form an opinion about it, which you needed to flesh out during voir dire in jury selection. But that's a small little city up there in old Moscow, that county, right? Change of venue, go to Boise, right? They're worried about scheduling. The judge can change the venue sua sponte on their own. If that's what it is, we don't have enough hotels for the press. We don't have enough hotels for the family. School will be in. We don't want to disrupt witness. It's a criminal trial and a quadruple murder. Hate to inconvenience everybody, but did I mention it's a quadruple homicide? Right? If the defense needs to get more people, then they need to ask for more money to get more people to review the discovery. But his defense is, it wasn't me. I was out driving around. Now, I'm sure there's a bunch of more discovery out there that maybe puts him there or close by. We know he was driving around the area in the vicinity. That's the issue. That's your alibi. I was in the area driving around, but didn't kill 4 people. I'm pretty sure I would have remembered that. Yeah. We did some weird, quirky little things. Now, obviously, he never has to testify, but if he didn't do it, he should pop on up there on the stand. If he did do it, he can't. because, he didn't, but he's his own best witness at that point. I did not do it. I did not do it. I was out driving around. I know it may sound weird, but I live in this college town. It's just weird. And I have lots of thoughts, and, I've had a lot of mental health issues over the years. And I find that driving at night, whatever, helps me calm down. Testify to that. How's your DNA there? You know what? I have no idea. No idea how it got there, but I've never purchased a knife before. Never purchased a sheath. Where are the records? Do they have the records? As far as we know, no, I don't. If they do, that's a bad fact for the defense. But this is the problem with the practice of law these days. In the age of technology, they want to download and save and dump every little thing. Then it releases, well, we downloaded the phone. Okay, well, what about this? Oh, then we're going to get search warrants for every application that's on that phone because we believe it may be related. There may be things of evidentiary value on that phone. Defense doesn't necessarily need all that. I know you got to review it. But at some point, I have a super chat here, but at some point, you got to go try the case. Clumsy clairvoyance. The judge in the Richard Allen case, will she recuse? I'd be surprised. Judges don't like to be told they're wrong or that they're unfair and impartial. So I think she's going to fight it to the end. But now it's an issue, and they can go through the appellate issues and things like that. But jump back to Kohberger. Go try the case, right? Kind of like my little protection order hearing today. I could have got a continuance. Judge, he showed up with 4 exhibits and a video. I need to continue the case to prepare. Why? Let's do this thing. My client did what she didn't do what was being alleged. Let's do it. Right? Hell, my best questions came from their own evidence because the other attorney hadn't thought that one through just yet. So you got to stop looking for that perfect document, looking for that thing. Eventually, you have to go try the case. And that's the problem. We're creating too many litigators, and we have less trial attorneys. Nobody wants to go try cases anymore. It's crazy. And there's a difference. I told you, anyone can be a lawyer. Just about everybody can be a litigator, right? Litigators are people that always looking for that document. If we submit enough interrogatories in this civil case, they will ultimately produce the document. No, they won't. I hate civil litigation. Why? It's not about what they give you. It's about what they don't give you. And then they settle on the courthouse steps because, they're not going to risk a bigger judgment when they're only a few $1,000s away. Sure, every now and then there's the big case that goes. Very rare exception to the rule. Trial attorneys go. Like I said, today, let's go do it. I got my calendar's open today. I thought it was going to be somewhere else, but I got coverage for that. Someone in the office took care of it for me, which was great. So let's do this thing. Sure you want a continuance? Nope. I'm ready. Doesn't your client have Fifth Amendment issues because of the criminal case? Yep. Let's do it. Let's do this. And we won. Good old-fashioned cross-examination. Eventually, you have to go try the case. So, even goes for prosecutors too, right? They're always looking, well, you sure your client doesn't want to deal? I'm sure there's negotiations behind the scenes on the Kohberger matter, the Allen matter. Well, you got to do this. Well, you got to take this, whatever. Just go try the case. Go do it in the time allotted under the Constitution of your state. Go try the damn case. Okay. Super chat. Let's take a super chat. Thanks, Frank. Do you think the judge will ever recuse herself? No. Clumsy clairvoyance? No, I don't think she will. Because the judges don't like to admit they're wrong. They don't like to be told to get off the case, even though it may appear somewhat obvious and the appearance of impropriety. They're like, well, if I didn't think I could be fair and impartial, I would recuse myself. Okay, judge, but we're asking you to withdraw, recuse yourself because you're being fair and impartial. You fired us. We want to fire you now, Judge. Don't like it. Doesn't feel so good, does it, Judge? You take it kind of personal, do you? How dare you question me? I don't think I'd be a fair and impartial judge. Right? What do you mean I'm an incompetent attorney? That hurts, Judge. What makes you think that? Well, Judge, after all, you had the mother of all emotions, the Moam, and you poo-pooed it like nothing. You didn't even read it. And from here on out, you had all this ability to make life a little better for Mr. Allen, but you refused to do it. Yeah, I'd kind of say, Judge, it kind of looks like you maybe not being fair and impartial. Oh, you don't like that, Judge? Oh, because remember how you fired us in private because you didn't want to make it public? Well, we're going to make it public. So I'm telling you, Richard Allen case, knockdown, drag out. It's going to be a fight. It's going to be a street fight. And we love that kind of stuff. We love good lawyering stuff. All right. The Crumbleys. Frank, can we pull up that video? All right. Frank, the hardest working man in show business, pulling up the video of the Crumbleys. It was released. It basically was them finding out that their son had been convicted. It's really quick, this little quick clip here. All right, we're seeing. All right, seeing if Frank is earning the title, hardest working man in show business. Here we go. It's up there. Oh, we got no volume. Okay, this is a scene where their mom's saying, why? Why? And the dad saying, I love you. I love you. Sure, you may be slaughtered everybody, but we still love you. Why? Obviously, the Crumbleys, their son, Ethan Crumbley, bad human being. He's a bad kid. All right. Did lots of bad things to lots of people, caused lots of pain and misery and death. And old Ethan is a bad guy, and he is going to spend the rest of his life in prison. As well, he probably should. He is a danger to the community. You cannot go in and shoot people and expect not to go to prison. I'm not sure why some people think that wasn't a whodunit. It was yes, he's a juvenile, so they're not gonna, do the death penalty on him. But I was having this conversation the other day, like, oh my God, that's like a really long time to go to prison. I mean, they're a good kid. And I say, well, let me explain something to you about the criminal justice system. Obviously, it's like all things in life. You want some little good order and discipline in society. And, there's kind of rape, murder, violent crime, and everything else. All right. And so, everything else is, minor stuff. Sure, people get hurt, but, drugs or whatever. I mean, it's minor stuff. The violent stuff is wrong. And so as I was explaining to this individual the other day, that the judicial system basically says, if you are a violent person, i.e. you harm, you hurt, kill, maim somebody, we're going to send you to prison. Well, why does it have to be for so long? I just don't understand why it has to be so long. Well, the reason why we send dangerous people to prison for a long period of time is that so basically they're too old when they get out to be able to harm somebody. That's why. Well, they're so young. Well, they're not so young. They're an adult. Maybe a young adult, but the reality of it is if you're a violent person and you have these violent tendencies and you can't harness those violent tendencies where you actually have to go hurt somebody, and not in like a self-defense type situation, we're going to lock you up so that when you do get out, if you get out, you're too old to really engage in any harm, right? Because past performance is indicative of future results. That is the general penological system in the penal system, right? Like, well, it's young. Okay. Guess what? If you commit violent crime, and even if you're young and, the old frontal lobe isn't completely developed, and I get it, kids are dumb and stupid, and boys are even dumber and stupid. And they do that nonsense, and they go around, shooting up places and what have you. The reality of it is like, one, you're doing dangerous stuff. And two, maybe you're not the sharpest tool in the shed. Like, if that's how you think that you react, oh, somebody did something wrong to me, I'm not going to call the police. I'm going to go in my caveman mode, and I am going to go shoot up people. If that is your process thinking by the time that you are a young adult, okay, you're probably a danger. You really are. And that's the way the judicial system looks at it. That's the way prisons are set up. And that's it. And you say, oh, they're mitigation, they can change. You're right. They can change. I've seen people. I had a case once. We did a post-conviction on a kid. He was a juvenile. I think he just turned 18. I didn't do the trial, but there's some shady stuff going on in that case. And I think it's up for review basically now, even though everybody poo-pooed it once again. Oh, you mean there was some sided deal that wasn't disclosed by the prosecution? Well, why should we have not turned that over? I don't know. Anyway, don't even get me started. And I've seen people that have changed. But, that guy, the entire time he's been in custody, not a single write-up. The guy, when I read him, had been in custody for over 20, I think it was almost 25 years. I was expecting some hardened prison guy, tattoos on his face or something. Had salt and pepper hair, polite as could be, just respectable young man. He's like, but I didn't do it. And he was found guilty under not as being the shooter, but as, being a part of this robbery under the old law of felony murder. And just bad stuff, man. Bad stuff. And so people can change. I've seen that, but there's things for that. It's called clemency. So I don't know. Jumping back here to old Ethan, shot and killed 4 students, injured another 7 more, including a teacher back in November of 2021. So mom's on trial for basically negligence, saying that she knew or should have known of a dangerous situation and she didn't do it. And part of the testimony that's come up is, well, the same school counselor that, called the meeting didn't exactly call anybody either and say, oh my God, we have a mental health crisis. We must do something. And they're the highly trained professionals. What are we supposed to do? Hate to keep jumping back to my hearing today, but, there were some situations where asked the witness, well, you said there's a terrible thing, right? I mean, oh my gosh, they, he grabbed you and all this other stuff. Yeah. Oh, and how'd you get home? Oh, he drove us. Oh, really? Okay. Well, how'd you tell your parents you got home? Oh, I had my friend lie to me or lie to my parents so I wouldn't get in trouble because I was with this boy. You didn't put that in the police report, did you? Huh. You didn't take that on on direct examination. I told it on cross-examination. And this is the problem that I have with the case against the Crumbleys, right? Are they going to get the Parent of the Year award? No, they're not. Were mistakes made? Yes. But where does it stop, ladies and gentlemen? I mean, why stop at the parents? Maybe they had some close friends, neighbors, grandparents. Why didn't they see the signs? Charge them all, I say. No, I don't. I'm not saying that. I think it's ridiculous. This country of ours is premised upon the notion that we charge people for acts that they commit, that they knowingly commit. Do you really think that the parents said, I think he's going to go shoot up the school today? Good for him. Good job, son. Go forward. Make a big splash. Look for your name. We'll meet you down at the police headquarters. We're proud of you, son. I mean, that's really what the prosecution is saying they did. They would have had to do that to found guilty of this. I got a problem with the prosecution of this. Ethan, send him to prison, lock up the key, lock him up and throw away the key. I get it. I just don't think that the parents should be charged. Like I said, where does it stop? Cops, school counselors, charge them all criminally. I mean, they're suing the school. The parents of the victims are suing the school for the negligence, not of the Crumbleys, but of the school people who didn't act. Well, if it's good enough to sue them, I mean, it's a negligence standard after all. Why not charge the people in the school? Go, principal, counselor, anybody that's had interaction with it. How about the teachers themselves? Where does it end, ladies and gentlemen? And everybody thinks it's such a great idea until it affects you or your family member or somebody you know. This is unfair. They didn't know. Right? It makes sense if, somebody is drunk, sloppy drunk, and you say, hey, drive yourself. Here's the keys, man. That's different than saying, hey, no, I'm going to take away your keys. You need to come in the house, sleep it off. And the guy gets up, takes the keys, steals the keys while everybody's sleeping, and drives away, kills somebody. Two totally different scenarios. Wouldn't you agree? I think so. But hey, what do you know? What do I know? What do I know? Can you believe we got along tonight, but we got all fired up. That's what happens when we get fired up like this stuff. But of course, what can we do when we have we got to have our dumb criminal of the day. We got to do it. And of course, coincidentally, where do they come from? Florida. God bless Florida. Now, don't get me wrong. Florida just has better public laws as it relates to release of this stuff than a lot of states. A lot of states, like state of Colorado, we cannot release that. There's a privacy interest there involved. We can't do anything. That would be bad. Okay. I mean, are you saying you can't release the facts? I don't know. Anyway, our dumb criminal today is Celia Barrett. Speaking of alcohol, apparently she was a little bit intoxicated and ran down to the local convenience store. And what did she do? Well, she was wielding a vegetable peeler. Yeah, it's all fun and games until somebody attacks you with a vegetable peeler.
That's a dumb criminal.
No, that's not her.
Yeah,
No, it's a different lady.
Oh,
did I mention that our lady was naked too? Naked attacking people with a vegetable peeler. You know who really should be charged? The manufacturer of the vegetable peeler. Couldn't they foresee that it was going to be used as a potential weapon? And what did she do naked while with this vegetable peeler? Well, she threatened the convenience store clerks. And this is where I draw the line. Miss Celia Barrett. You destroyed a Red Bull display. Now, I've been trying to come back on my Red Bull, but it's tough, right? We got the Magic Mind stuff. I drink that and a Red Bull now. Okay? Because I need that little pick-me-up in the morning. All right? But when you start destroying Red Bull displays, that's where you've lost me, Miss Barrett. I think if you had come to my firm and I said, you assaulted a Red Bull display, that's it. I can't do it. I've represented murderers, rapists, child molesters, but you start destroying a Red Bull display, you start affecting me, Miss Barrett. We can't do that. Still a little unsure why Ms. Barrett was naked, why she was assaulting everybody with the vegetable peeler. I'm assuming it's a potato peeler or some sort of, cucumber or something. I don't know. Apparently just a little too inebriated. Started to notice a trend yet in the dumb criminal of the day. Usually involved alcohol and really stupid people. And you'd be surprised. We got so many people there for a while. Oh my God, Scott, how can you use a dumb criminal of the day? That word is so mean. oh my gosh, they're not dumb people. No, not all the time. There's some dumb ones, and I can back that up. But they're doing dumb things, and usually involves drugs and alcohol. So there you go, ladies and gentlemen, our dumb criminal of the day. Even on our live show. Celia Barrett, congratulations, you made it. Now, I expect full restitution on the Red Bull display, because I'm telling you, if somebody knocked down my Red Bull display in the other office over in the kitchen, my little fridge, oh, we're going rounds, okay? You don't mess with the Red Bull, right? You have plenty of Red Bull. You have it in the fridge, but you don't destroy it. I'm telling you, anyone knows me, Red Bull. Open up my refrigerator at home, Red Bull. Refrigerator here, Red Bull. It is the drink of champions. All right. Had 2 Red Bulls this morning before I went to court. Kick some butt today. So there you go. All right, ladies and gentlemen, we got to go. Why do we have to go? We got to go do our Patreon show. Hey, what the hell is that Patreon show? Well, that's where we're going to continue the conversation of what we're talking about here today. But guess what? Our Patreon members, not only will get all their questions answered that they send in, we will give you a call-in number to the CrimeTalk Batline number where you can continue the conversation, and we will have a conversation about what you want to talk about because you're a Patreon member and it's your private show. And I think it's very reasonable. Like a minimum $5. You got different levels. Heck, if you pay me enough money, we'll hang out together. All right. I just consider me like Miss Hill. It's all about the money. Okay. We'll answer your questions. We'll take your calls. And I think our biggest Patreon contribution one time was $1,000. And he just wanted legal advice. And I said, you didn't have to even become a Patreon. I would have given you the free legal advice. But we appreciated that, made me feel good about myself. Making $1,000 for, gosh, that's like $4,000 an hour because I think it was like a 15-minute call. Didn't even have to do that. Could have asked this question here. All right. So if you haven't joined, join. The link is below. We'll be there in about 5 minutes or so because I already ate my dinner. And we'll go for a little bit there as well. So once again, thank you for being here. Appreciate everyone. I know you have lots of other things you could do, and you took the time to watch us. Hope you received something of value, and thanks for watching. We'll see you next time. And remember, the Constitution matters.